Yes, and I guess I would first like to thank Yinka for agreeing to take part this evening with her webinar. Uh, Yinka has kindly been a presenter in the past and an expert in immigration law, and has spoken in one of our law school webinars about the immigration consequences of Brexit. And I think Em and I were having preliminary discussions for another one along those lines in the autumn as part of our law school webinar series. I think the dust would have settled a little bit, and Inga's an expert on that, on settled status and so forth. That's another subject, but he's kindly agreed to switch hats, as indeed I have, gone from host to I guess, the presenter for this evening's webinar about some subject matter that I have a research interest in and a teaching interest in. And so anyways, I'll hand over to the host, Yinka. Thanks again.
Thanks, Paul, and thanks, Heather, as well. And welcome everyone to tonight's webinar on, it's titled Begum and Assange. I hope I pronounced that correctly. Stains in Britain's Conscience. As Paul has mentioned, Paul is an academic in the law school with interest in international criminal justice. He's also got expertise in other areas of law, specifically human rights law and international human rights law as well. But for tonight's webinar, we'll be looking at the cases of Shamima Begum and Julian Assange. A lot of us must have heard of both of them. And the issues around tonight's webinar are some are a bit contentious, some may evoke some personal sentiments, but it's an academic discussion, and we'll welcome everyone to just have objective discussions on these two cases. And each of these can be seen in different ways as well. And indeed, each has given rise to, as I mentioned, very, very strong opinions. And the question is, should Shamima be deprived of her citizenship and be left in a no man's land in a Syrian camp for displaced persons with no place to go? Paul would answer some of those questions today. And in relation to Julian Assange, should he be extradited to the US to stand trial for espionage and computer hacking and thereby face a possible 175-year prison sentence? I'm not sure who would live to 175 years in the first instance, and I think the questions in relation to giving a sentence to someone for that length of time. And I hope to be able to, I'm sure Paul will be able to shed some light on both cases so that whatever views you hold, your opinions, again, will be a little more well informed. So the way we're going to do this is I'll ask Paul some questions in relation to Shamima Begum, and then ask him some questions in relation to Julian Assange, and Paul, being the expert in this field, would answer as best as he can. And if you've got any questions, like Heather mentioned at the start, you can type the questions into the chat box, or just wait till the end when we'll take questions and you can ask the questions then. So without wasting any more time, we'll go first to Shamima Begum and Paul. So prior to discussing in more detail, perhaps you could tell us a bit more in a broader context about who she is and about the case. Over to you, Paul.
Okay, thank you again, Yinka, for that. I guess I thought it was appropriate to provide a little context to well, both cases. We're starting with Shamima Begum's case firstly. And also, I was just thinking today, I'm running over my mind about tonight's event. Of course, these cases are ongoing, both of them, and so what I want to do is, tell you about what's happened so far, the state of play in the cases, and I suppose I can try to be a seer and look at a crystal ball gazer and look into the future and tell you what I think will happen. But of course, I don't know for sure. Obviously, what will happen. So, and that's what I guess we normally do is well, in the law school, or what I normally do is read the applicable law and jurisprudence and academic articles on a subject and newspaper reports and any other relevant information I can find and form an opinion and comment upon it in my own publications and where appropriate, tell my students about it, and with a view to informing, I guess, the readership of the journals and newspapers I publish in, and my students in class, to make up their own minds about it. I'm not, and I feel the same way about tonight. I'm not here to expound and try to get one view across to you or the other. I'm just to tell you what I think in the context, and then indeed I welcome your comments at the end, because I'm sure how many we have tonight, that but there'll be a number of different opinions, and that's just right, that or that's just I guess to be expected. Okay, so that's the first very general point. They're ongoing, and Shamima Begum's the context of her case is a phenomenon that's been in the news for the last decade or so, perhaps, even though it's has considerable historical pedigree in foreign terrorist fighters, where individuals have gone abroad to fight for a cause, not being the country, a cause being fought by the country from which they're from. I say historically. I remember hearing stories when I was growing up. I can't remember what context, or maybe it was even movies or something, but we would go abroad to fight in the French Foreign Legion for a cause France was engaged in. So there's a considerable historical pedigree, but in more recent times, individuals have left the United Kingdom to take part in conflicts, by and large, in the Middle East. And I suppose in other parts of the world, famous instance in the Spanish Civil War, of course, where individuals left the UK to fight there. But in recent times, this has happened, and it has captured the public consciousness in that of the state, the government, and we're faced with a quandary of what to do in response. And the UK has responded in several ways to the phenomenon of foreign terrorist fighters, one of which is the deprivation of nationality. And that's what we'll come to just in a second. Others include criminalization of certain acts overseas, entering into certain areas. And indeed, another aspect is temporary exclusion orders, where individuals can be prevented from returning to their own country, their country of nationality, even if they're single nationals, sole UK nationals, you say born without even non-UK parents, and can be deprived or prevented from entering until with certain conditions attached on their entry. And I say the one aspect of this response that I would speak about and is applicable in Shamima Begum's case is citizenship deprivation. So that's the broader context of what's there of her case, that she is considered a foreign terrorist fighter, has gone abroad, and has had her citizenship deprived by the UK government. I think that's it. Do I know where we are in questions? I don't have my questions in front of me.
I'll just to follow up on that. So from what I could deduce from that, you're saying one of the responses to foreign terrorist fighters one of the responses of the UK government to foreign terrorist fighters is deprivation of nationality or citizenship. And I guess the follow-on question to that is, can the UK take away the nationality of its citizens? Isn't that unlawful under international law?
Well, I guess that's the nub. We get into the nub of the issue, or in a general sense. In a general sense, the answer is yes. There's a longstanding treaties governing statelessness, and I suppose, well, I guess the answer could be that, or the answer is, that gives away the answer. It's unlawful under the terms of those treaties to deprive an individual of their nationality if it leaves those individuals stateless. So a sole national. Wouldn't apply in my case. I hold 2 Canadian passports and British passports now, so I could be amenable to citizenship deprivation by the United Kingdom, or indeed by Canada, I suppose, as well. It would still leave me with a nationality. But there's the 1961 Statelessness Convention, which has a general obligation to prevent statelessness, or it exists to prevent statelessness, and puts an obligation on the state parties to that treaty not to make individuals stateless. There's a slight exception to that. If a country entered a reservation at the time of concluding the treaty, there's a possibility that they can continue to if at the time they had a policy of making people stateless in their law, they can continue to do so. But generally speaking, yes, and you could see the sense in that. I think everybody would see the sense in that rule, you know, in general terms, that countries cannot make individuals stateless or undesirables stateless in their society. I guess the simple point being, well, where are they to go? You know, if they don't have a state they belong to. And I always think of that movie. I don't know if it wasn't called Airport. I can't remember what it was called. Maybe you guys would tell me in your chat box or at the end, where an individual stuck in an airport, you know, stateless, has to just live there because there's no place for that person to go. Has no passport, is stateless individual. So it is a response of UK, the deprivation of citizenship. There are 2 applicable UN-sponsored treaties governing the issue to attempt to reduce and deal with the issue of statelessness. And it may arise in several ways. Just the deprivation of nationality is one way. Others, as being born in a war zone or some other in some other circumstances whereby that individual is not assigned sort of a state of nationality at birth. So that's a long-winded answer to say yes, there are rules, and there's a general prohibition on the deprivation of nationality resulting in statelessness. Okay,
Thanks for that, Paul. I think the movie you made reference to, there's, if memory serves me correctly, is The Terminal by Tom Hanks. I think so. I might be wrong, but I think I vaguely remember that particular film. So I mean, I know we've been talking a lot about Shamima Begum. Maybe you would want to sort of talk to us a bit more about who she is and what happened to her, just to remind some of us of the facts of that particular person. Over to you, Paul.
Yeah, great, thank you, Inka. Yeah, of course, the facts are I think, significant. I suppose in every case the facts are significant, but particularly so in drawing a conclusion about what we're getting to at the end of our hour today, or 40 minutes by us and 20 for you guys for questions about our views on in essence, the morality or ethics of what is proposed or what is in the process of happening to both Begum and Assange. She was aged 15 when she left her home in England with 2 friends and ended up in Syria. She went and professed and stated this in her first interview, that she went to support or to join Islamic State. And I think shortly after arriving, she married a Dutchman. I assume maybe 15 or 16 at the time. I don't know how old she was when that happened. And has since given birth to 3 children, and all of them have sadly died in the conditions of Syria. She's presently detained in a camp in Syria, and where she has been for the past 2 or 3 years or more. And we'll come on to this in a second, but her litigation is still in the process. It's still pending the decision of the Supreme Court in her case. She and the Home Secretary Sajid Javid at the time invoked provisions in the British Nationality Act 1981 and deprived her of her citizenship when she came, I think, to the forefront of the news. And how that happened, I think it was a Guardian reporter I may be wrong, or the Times, maybe the Times, but a newspaper reporter found her in a camp and interviewed her with video footage. And you may have seen this if you're interested in the case, and some of you guys are because you're here, I think. And saw that interview with her. And in her first one, she was and has been held against her, made some ill-considered comments, and someone will say, well, that's where maybe her true feelings, but about Britain getting what it's deserved from Islamic State or so along those lines, and she was 21, I say, sorry, pardon me, 15 at the time of leaving. I think she's now maybe, I don't know, 2021, I think. And she's still there, and her case is pending. And I guess the point is that she was born in, well, one point, I think, a material fact to my mind, born in the United Kingdom, lived her whole life here, educated here and raised here, and but to Bangladeshi parents. So both her parents, I think, still had Bangladesh nationality. And then, so as she joined this, and she was, in the cause of living in the cause with Islamic State, and then, of course, they were eventually defeated, and so those individuals like herself and a number of others were held. I think she's in a camp, I think, run by Kurdish forces in Syria. Okay, I think that's it. We don't get to spend too much about Shamima Begum. We'll come on to, I think, her litigation in a minute. Yes, Yinka.
No worries. I was going to ask some follow-on questions for that, but I'm just sort of conscious of time. But just to ask a last question about Shamima Begum before going on to Julian Assange. Is the deprivation of Begum's citizenship, do you think it's just, ethical, or morally right? I know that's a sort of loaded question. But yeah, I'll leave that to you, Paul.
Okay. Well, I guess I'll just continue again with the follow on about the state of it. She challenged her loss of citizenship in the tribunal that hears such cases, the Special Appeals Immigration Commission. Deals with nationality matters and matters of national security, and then she lost, and then an appeal was taken, and then it's ended up in the Supreme Court has heard the latest version of her case in November, where arguments were made, and that decision is pending. And the issue that the Supreme Court was faced in general terms is whether she should be allowed back into the country to take part in her appeal against the deprivation of her citizenship. So it wasn't directly faced with the question, was the deprivation unlawful, but rather should she be allowed to take part in the litigation, which I guess she's centrally involved in her future. And indeed, the Court of Appeal, in its decision, held that it was clearly, that appeal was clearly affected and negatively affected from her point of view by her absence, by not being able to. And the Court said that her appeal is not going to be fair because she's not able to fully take part in proceedings because she's trapped in a camp in Syria and not in the United Kingdom to take part in instructors, solicitors, and so forth. And so an appeal was taken to the Supreme Court, as I've said, heard in November. And indeed, I was looking upon this, and I guess if you guys are interested, you can see go to the Supreme Court site and find recordings of the arguments made in her case on this UKSC website. And we're awaiting a judgment of the Supreme Court. Of course, I don't know when that's going to happen. It's not imminent anyways. I was looking to see if a judgment would be handed down imminently. So that's the legal position, and I suppose there's a couple issues the Supreme Court was, and I guess the law as such, and is something that, as lawyers, I tell my students in human rights law, the law isn't really concerned with, or necessarily concerned with, what's fair or what's right or what's just. And some people may take issue with me on that point, but it's just what's lawful. And that's the issue. And ideally, there is a parallel between what is lawful and what is right or what is just or morally defensible. But that's not necessarily the case. For example, Begum's citizen deprivation could be lawful. I mean, according to UK law, and broadly within the terms of the international obligations it's acting under. And some people could say, well, that's just not just to have a 15-year-old life permanently affected for a decision taken at that point in her life, where I suppose many others have done worse things, and in and maybe the same age or older, and don't face nearly the consequences or sanctions that she is, mainly because I suppose I think of her media profile, this interview, and her being a cause celeb, as it were, and the fact, and just happenstance, the fact that she has foreign-born parents, and that if somebody did exactly the same thing as a 15-year-old girl that had two UK national parents alone, this couldn't happen to them. And indeed, and those with the foreign parents, and I was getting the stats on this, and they're sort of anecdotal. I get them from newspapers. I don't have official stats on the issue, but most of the individuals that have done this come back and are now, living in the UK, not facing the situation that she is. So she's been singled out, I think, in part because of, I think, of this interview abroad, and her, she's been sort of chosen or picked by the media to be a sort of poster child, some sort of, people are interested in it and follow her case. So the Home Secretary at the time wanted to appears to act, be tough on crime, tough on terrorism, and deprive a young girl of her British nationality. So my personal view is, and I know people would disagree with me on this, I think it's not just to deprive her of her citizenship. I believe what should happen ideally is should be allowed to return to the United Kingdom, appeal her deprivation, and prior to that, I suppose, or I don't know in what sequence it would happen, but she also should face consequences of her actions. She should be tried for offenses, and there's a number of possible offenses that she could be tried with. I think under the Terrorism Act, showing support for a prescribed organization is unlawful. There's an evidential issue there, whether it could be proven what she did beyond a reasonable doubt in a court to get a conviction. I think that could be a challenge. And there's also other measures that could be imposed on her, restrictions and terrorism prevention and investigation measures. For example, the TPIM Act contains a number of restrictions that can be imposed on an individual for a duration of 2 years to restrict their activities. So if it was thought that she was a danger or a threat to those UK society or those in the UK on the basis of terrorism, then she could have restrictions placed upon her. So that's what I think should happen in her. I do think it's not ethically correct to sort of banish her. And another, I guess banish is the word, another element to that story is that Bangladesh, this citizenship, is a country where the SIAC held that it was possible in Bangladeshi law for her to get Bangladesh citizenship because she was under a certain age. She could claim it on the basis of her parents. But my understanding from reading the case in media reports, Bangladesh as a country has refused to accept her, and indeed said that she could be punished, indeed perhaps even executed if she showed up at Bangladesh to say, let me in, and so she doesn't have anywhere to go. Another possible option could be the Netherlands, and I don't know the state of her marriage to her Dutch husband and whether the Netherlands' view on this, indeed whether they would even view her to be validly married. But I guess that's a sort of a complicating aside, but generally I don't think she has anywhere to go. It's a long-winded answer, and pardon me.
That's all right. I'll just ask one quick question. Just again, it's more of your opinion on that one. I know she came into sort of, I wouldn't say global prominence, but I knew of her when she had a third child, and I think it was a BBC news reporter. I remember watching it on TV at the time. I don't remember his name now. But would things have been different for her if her, the last child survived, for instance? Because then the government would have had to take the best interest of the child into consideration, looking at Section 55 provisions in relation to the child. So if the child had survived, do you think that would have sort of helped her from a legal perspective and from the perspective of public opinion as well? Just a quick answer to that one, Paul.
I think it could well do. You're right to say under the UN Convention on the Rights of the Child, and then the provision incorporated into UK, there's a lawful obligation to take the best interests of the child into account in any decision affecting that child. So there's that legal obligation upon the United Kingdom. Whether that would mean, she wouldn't have had her nationality deprived and being allowed to enter, I don't know, but it would certainly be a relevant consideration and one that would, I assume, been litigated. Her lawyers would have, I would have hoped, would have put that forward. So I think it would have had an influence. Whether that would make the public any more sympathetic, I don't know. I don't think so, probably.
Yeah. Thanks, Paul. I mean, we could go on and on about Shamima Begum, but I think we'll pause there for now and go on to the second aspect of today's webinar, which is on Julian Assange. I know a lot of us have heard of Julian Assange, but I wonder, Paul, if you could remind everyone about the law and context around Julian Assange's case.
Okay, I mean, I guess certainly can, and I will. I guess one point that springs to my mind immediately is, and why are these two together? And I think, are they in there because they're very different, obviously, and radically different cases and different laws applied, and they're different individuals and accused, I guess is the right word. I don't know if Begum's accused of anything, or if he said she's a foreign terrorist fighter. Assange has been accused in the United States of certain crimes, never convicted there of them, never been tried of them. So they're very different, but I guess how I see them as I say, one of the title of our webinar, they could be perceived as stains on Britain's conscience, or sort of a negative reflection on Britain adhering to ethical or just behavior in the realm of transnational criminal justice and foreign affairs. And I think Britain is historically known, and whether this still stands, is a country adhering to the rule of law and human rights and its international legal obligations, and promoting indeed human rights, including freedom of expression, right to private and family life, right to be free from torture, inhuman, degrading treatment or punishment, right to life, all of these, human rights, civil and political rights in any event. And so how these cases, I think, are related is that they arose in the general context of transnational criminal justice and foreign affairs, and they could be seen, as I say, as reflecting badly on Britain's standing. Okay, so I didn't make that point earlier. Julian Assange, I've had a webinar in the past about him, and I'm following his case quite closely, and I've written some things about it. It's also ongoing, of course. The present state of play is that he was successful in his extradition hearing, decision handed down on the 4th of January, and his extradition was held to be barred on the account of oppression under the Extradition Act 2003 on the basis of his mental health, and the conditions that he would be afforded in the U.S. criminal justice system. And the district judge commented that his intelligence was such, so intelligent that he would be able to defeat any suicide prevention programs the American prison system would impose or apply in his case. And so there was a real risk that he would commit suicide if extradited to the United States. And so, and then I think just very recently, the prosecution have, the United States is the prosecution acting, sort of CPS would act on behalf of the U.S. in extradition case, and filed their appeal on that point. And I think the decision where now was could possibly happen is there could be a cross appeal by Assange, his lawyers, because that oppression point was only one of a number of arguments made by Assange in the course of his extradition hearing. Others being, as I mentioned, freedom of expression, under Article 10 of the European Convention. The oppression was another one. The effect of politics on his case. There's an extraneous circumstances bar under the 2003 Act that his trial could be motivated by political considerations, or his trial could be affected by political considerations, or his extradition request motivated by them. And there was others, I think, other arguments, other human rights arguments, and so we're about torture, inhumane, degrading treatment, about the prison conditions, and his right to private and family life, and so forth. But they were all rejected, save that one point about oppression and his mental health. And he's accused, I think everybody would know, I assume, of espionage by the United States, and of one computer hacking charge following his WikiLeaks activities, where the WikiLeaks website published a number of classified U.S. documents, and that eventually spawned. It took some time, but eventually spawned U.S. Indictments, grand jury indictments against indictments in the plural against Assange, and his hearing took place last year, and the judgment was handed down on the 4th of January. So I mean, but also, I guess, pending his appeal, I guess, where is he today? I mentioned where Begum is. Assange is in Belmarsh prison. His bail has been denied. So he's been there, I think, reading just today, I think, for 500 days on a remand ever since he was removed from the Ecuadorian embassy in London. And that's the state of play for him. There, so the prosecution is appealing. If they're not given, well, they're seeking leave to appeal firstly, right? So they need permission to appeal. And if leave isn't granted, I think that will be the end of it, I'm pretty sure. If leave is granted, then a substantive appeal will be held. If he is ultimately successful, either at this stage or later on, I assume what will happen to him is the UK will deport him back to Australia, his country of birth, I assume. Anyways, that's a long-winded answer, and that's what's happened to him. The U.S. is still seeking him, is going to appeal the judgment of the district judge on the 4th of January, and with a view to still seek his extradition. I know there's been representations in the U.S. I've been reading about. Of course, in the interim, there's been a change of United States president. It's thought that perhaps Joe Biden will be more sympathetic or less hostile, anyways, to Julian Assange than the previous president was. Of course, nothing to date, so far as I know, has happened in that regard, but I know there have been representations to Joe Biden. So that's a very long-winded answer again, Yinka. I'm thinking I'm speaking too much.
Sorry. You've made a lot of reference to extradition. Just for the benefit of everyone listening, can you tell us what is extradition?
Okay, yeah, well, simply, of course, that's, I guess, the framework, the critical point. Extradition is a process where a convicted or accused person is lawfully transferred from one country to another. In the UK, the statute applying is the Extradition Act 2003. And I guess coincidentally, there's an international treaty. Extradition is generally governed by bilateral treaties. There is a treaty between the US and the UK of the same year, governing relations between the United States and the UK. And it's a pretty heavily criticized agreement. And a number of well-known people, the NatWest 3 bankers and others have been extradited to the United States under the terms of that treaty.
And so if, for instance, if Julian Assange had gone to a country with no extradition treaty with America, would he have to worry about his, sorry to deviate a bit from the questions, I just thought to just shed a bit of light on extradition, if you could. Would he not have to worry about a non-extradition country with America if he had been to such country, for instance?
That's a good question. The answer is, I guess, is yes. I guess he would have to worry less. I guess it depends on the country. A famous example here is Edward Snowden. I mean, wanted in the U.S. for I don't know exactly what, but I assume they're espionage charges as well. And he's been living in Moscow for the last number of years. Safe from the hands of the U.S. authorities because there's no agreement between Russia and the United States, and there's also there's political friction between the two, and so I think he's safe from extradition at present from Russia. How permanent that would be, I don't know. If there's when and if Putin is no longer the Russian president or some other factor that comes into play. And indeed, he's there. I don't know what his living conditions or standard of life would be away from his friends and family in Russia. I mean, the famous case, of course, used to be, or two other countries famous for that were Brazil and the great train robber Ronnie Biggs, of course, spent years and decades in Brazil, away from the long arm of UK law because no extradition agreement between the UK and Brazil. And also prior to Spain joining the EU and then the European arrest warrant of 2002, Costa del Sol used to be a nickname, Costa del Crime, where only gangsters and drug traffickers and others would go down to the south of Spain, safe from the clutches of UK justice. And that is generally not the case. Well, I'd say it wasn't the case until we had a Brexit, and now we'll have to see how the new arrangements under the Trade and Cooperation Agreement concluded on the 24th of December last year operate in the stead of the European arrest warrant. So a very long question, but the answer is yes, the circumstances would have been radically different. But the UK traditionally and the US have friendly relations. There's numerous cases in UK law where individuals have argued against their extradition to the US on the basis of prison conditions, pressure to plead guilty, right? There's this pretty severe plea bargaining system in the United States where if you plead guilty, you could get a relatively lenient sentence and perhaps serve it back in your home country. But if you plead not guilty and you're tried and convicted, the prosecutor will recommend to the sentencing judge that the book is thrown at you and you have the prospect of spending the rest of your natural life behind bars. And so there's that and other criticisms. But in general terms, okay, there's exceptional cases where, and Assange's may turn out to be quite an exceptional case where his extradition doesn't proceed. But in most cases, I don't know the stats on this for sure, but I would say, less than 5% of arguments against extradition to the United States from the UK are successful. I can think of, the high profile cases that make the news. Lori Love is a well-known relatively recent case where he also won an argument against extradition to the United States.
Thanks for that, Paul. I know, I mean, you did sort of talk about who Julian Assange was briefly at the start, but if you want to sort of give us a bit more information on who Assange is and why he is in the news, I think a lot of the listeners would appreciate that.
Yeah, well, that's a whole webinar in itself, I guess. But I think the highlights is, he was the founder of this WikiLeaks website and exposed state secrets of the United States and some other countries. And I think some of those documents and that information exposed really quite nefarious and unlawful activities, I think, under maybe some conventions or rules of international law by the United States. And many people would view that as a good thing, that countries should not engage in extrajudicial killings or other activities of dubious legality around the world just because they're able to militarily or technologically, and inclined to do so in the name of self-defense. Or international justice, whatever the reason why they would do that. I assume state security ultimately, and indeed as part of that, this exposure, and worries that have arisen in journalistic circles, you can see there's a number of supporters of Assange who come from it from that perspective of the sort of the chill or the anxiety caused in editorial offices and by the US's action in his case, and certainly that's one component of the supporters of Assange. And I mean, there's a considerable number. I mean, that's just one group. Others would, just be aghast at the activities carried on by the United States in some of their foreign policy, and feel that should be exposed and individuals should be held to account. And then there's individuals on the other side about thinking, well, and this was some of the argument in his extradition hearing, that by the exposure of some of that information, individuals' lives were under threat because individuals were named, and those that had past evidence or information to the United States in various countries around the world were named, and thereby, if you were working with the U.S. in some way or other, and your name was passed, made public in Afghanistan or Iraq or Pakistan or some other country, then of course your life or in your family's life would be under immediate threat. And so that's, I think, the gist of the case from the prosecution side. Not only was it this sort of espionage, but it had a severe possible consequence for those involved.
Thanks, Paul. And just to follow on to that, what are the latest developments in relation to his case?
Okay, I think as I alluded to briefly, but there's a hearing going to be in not too long, considering his leave to appeal from the district court judgment handed down on the 4th of January. If that goes ahead, there will be a high court appeal in his case, where the U.S. will attempt to convince the high court that the decision on oppression, on his mental health arguments was wrong. I mean, and then so his lawyers have to, the U.S.'s lawyers have to convince the high court that the district judge was wrong on that in that decision. I say there's a possibility of a counter appeal, right? So then the Assange's lawyers will again have a chance to make arguments on some of those things I mentioned already. A political influence or political effect, other human rights, or an abusive process argument, fair trial, torture, prison conditions, an Article 3 argument, and other arguments. And so it could be a complicated appeal, considering many of the issues that were originally appealed all over again. When that happens, I don't know, but I know the lawyers have recently, the prosecution lawyers have recently submitted their grounds for appeal, just this week or last week, I think. So it could go on for some time. I don't really know, or it could be coming to an end relatively soon. I'm very vague about that, but it's ongoing, and there's the next stage is imminent. I guess is all I can say.
Yeah. Thanks for that, Paul. I was going to ask some other questions, but you covered a few of them as part of this answer and the previous answer, and I'll just go to the question on how you think his case might end.
Okay, I guess I can say that how it might end, and then maybe I'll make a brief comment, because I'm looking at the time and I've seen some questions pop up, so I want to give you plenty of time. How it will end, I don't know. I mean, my original view was that he would be extradited. As I said, I think the presumption, the law is sort of presumptive of extradition. That's how it works. It's presumed a requested person will be extradited. It's sort of presumed to be the case, unless an argument barring that extradition is satisfied. And those arguments I've already explained, some of them, anyways. And so, and he was successful under this oppression argument on the basis of his mental health. And those arguments are only rarely successful. What normally happens in that instance is the requesting country, the U.S. in this case, obviously, will make promises or give assurances on how the requested person will be treated. He will get a certain medicines if they're required. He will get medical care of this nature. He will be housed in other cases where the prison is an issue, in a cell of this certain size, be allowed this exercise treatment or this exercise time and social or internet, whatever, these other aspects of incarceration. Make that promise to the UK, and then they'll say, oh, well, they've promised that in fact he's going to get these required drugs and this required psychological treatment or whatever, so we'll agree to the extradition. So I guess originally surprised. I was surprised on the 4th of January. I really, sort of live watching the Twitter as it was being handed down. Now I just don't know. I mean, because we're sort of in uncharted territory. I think prosecution appeals are rarely successful. So if that's the case, then the prosecution will be unsuccessful. And if the district judge's opinion is upheld, he'll be set free. He won't be extradited to the United States. And then I say, I don't know, as consequences, it could be deported back to. But even then might not be possible. He's now got a partner and 2 young children in the UK. And so that, he may be able to resist deportation on those grounds. If indeed he wants to stay here, maybe he's so fed up with the UK, he wouldn't want to stay here anymore. I don't know. So that's that. About whether it's ethically right to send him over there. I don't know. Say I'm sitting on a fence, and that's the title of my webinar coming out. That I don't know. I think there are strong arguments against his extradition. That were put forward in his extradition hearing. On the other side, every country has laws that act to protect its state security and national interest. The US, pardon me, is not unusual in having treason or sedition or espionage crimes on the statute books to prevent, or could be possibly to prevent terrorism, but to protect that state and its national interests as they perceive them. So the US, pardon me, is not unusual in that regard. But then the question is, did what he did damage U.S. interests, or in fact, or is that interest outweighed by exposing the nature of the activities that the U.S. had carried out? So I don't really know. Maybe I'd be on the fence. I know it was maybe more certain about Begum's case, and I think I'm going to sit on the fence if you'll allow me in the case of Julian Assange.